Hi, my name is David Holt. I'm the Research and Emerging Technologies Law Librarian here at the Heaphy Law Library, and this is the introductory screencast for Week 1 of Advanced Legal Research Intellectual Property. Little about myself as we begin. I've worked as a law librarian for 10 years. I am a Santa Clara Law alum, and I received my master's degree in library and information science with a specialization in legal research and government documents. I've been doing legal research work for both faculty and students over the last 10 years, including complex faculty scholarship projects. And I've also maintained our institutional repository. I liaison with our student journals. I manage our electronic resources and online presence for the law library. So you may be asking yourselves, why are you taking this class? To answer that, legal research is very important, particularly as you begin your legal career. Studies have indicated that nearly 45% of your first year in practice will be spent doing legal research. And we find that taking a single semester of legal research, as you all did in your first year with LawRaw, is actually rather ineffective in terms of developing professional level legal research skills. Law firms continue to complain that their first year associates lack sufficient skills. To further this point, a recent study within big law firms in Chicago, this came out 3 or 4 years ago, nearly 90% of new law firm associates lack the ability to define or narrow issues with secondary materials. 80% could not find relevant sources efficiently. And here's an interesting little fact that may be surprising to you. 40 to 80% of firms require their new hires to use print sources, and the reason for this, of course, is to save cost. Many of the online and electronic legal research vendors will charge you per search or per minute based on the plan that the firm has agreed upon with the vendor. Print materials, in contrast, can be used repeatedly without incurring any additional cost. Okay, the texts for this course are all available online. There is no required textbook. I will place items on reserve in the library if you would like to come in and use them. However, those are supplemental and not required for the course. Okay, the website for this class is on Camino. As this is an online course, we're using the Camino website extensively. It will contain all of our presentations, the readings, any supplemental materials, the screencasts such as the one you're watching now, and all of our exercises and handouts. I'll be adding materials to this website throughout the semester, so monitor it daily. And if we look at our Camino website here, you will see that we have the course organized by module. This is a 1 credit pass, no pass course, and each module has an assigned topic. So if we go to modules here on the left side of the screen, you'll see that we begin our week with statutory and regulatory framework. So kind of a review of what you should have learned in LawRaw, and then an introduction to research strategies and query formation. And so we're going to go over primary materials, secondary materials, strategies and query formation. And then I want you to fill out, for the assignment for this week, an introduction. And there are 2 quizzes to complete. They're rather brief. One is on Boolean operators, terms and connectors, and segment searching. And then the other is on research strategy. As we get into the second week, we get into the substantive material on copyright, so introduction, registration, and formalities, and that will be followed by copyright infringement and fair use, and so on and so forth until we reach week 8, which will end with licensing. The homework assignments for this course will be real-world research exercises, at least as much as I'm able to do that. They'll consist of short memo exercises, multiple choice, fill-in-the-blank responses. I want to try to make this course mimic real-world legal practice as much as I can. I recognize that that's difficult to do, given that it's hard for me to anticipate where your career path will take you after law school, but we will be trying to mimic what you should encounter in legal practice as much as I can. Okay, class policies are rather simple and straightforward. Again, this is a 1 credit pass, no pass course. If you do the assignments, you get a pass. All the assignments must be completed. That's the only hard rule that I will enforce. If you do not complete all of the assignments, I will give you no credit for the course. Okay, let's go over the learning goals for this course. Employers expect familiarity with statutory and regulatory framework, knowledge about government databases, including PTAB, manuals of procedure, application and litigation documents. We're going to go over all the practice materials, all the model documents, motion practice, forms, model interrogatories, and so forth. This is an IP legal research, and it does cover as much of intellectual property as is possible. We will spend quite a bit of time on patents, copyright, and trademarks. Not as much time on trade secrets, and very little, if any, time on other property rights, such as celebrity rights and etc. Okay, intellectual property basics. The types of IP law, we have patents, which are divided into utility, design, and plant. Patents, of course, have to be new and non-obvious. Copyright applies to creative expressions, but does not cover facts or ideas. The copyright duration is much longer than the duration given to patents. Trademarks are distinctive names, designs, and logos, and they are protected as long as they are used. Likewise, trade secrets, which are generally protected under state rather than federal law, last as long as the trade secret is kept secret. Basic elements of an IP right include the subject matter that it covers, the substantive requirements for obtaining that right, the procedural requirements or the formalities, the substantive rights that it provides once it's been acquired, exceptions and limitations to those rights, such as compulsory licensing, fair use, and etc., and then duration. There is a constitutional framework for intellectual property. Article 1 gives Congress 2 powers related to intellectual property. One is found in Clause 3 of Section 8, which is the authority to regulate interstate commerce. This applies to trade secrets and trademarks. And then Clause 8 of Section 8 gives Congress the power to enact patent and copyright laws. The text of Clause 8, which you may have already be very familiar with if you've taken IP survey, which if you haven't, I highly encourage you to do so, states that Congress shall have the power to promote the progress of science and useful arts. Notice that the term art is used in prior art, person knowledgeable of the art, and etc. You'll see that throughout intellectual property. Okay, Clause 8 specifically mentions writings and discoveries. So what about trademarks? Those are regulated via the Commerce Clause. Trade secrets, again, are typically regulated under state law. In terms of the statutory framework, there's a separate title in the U.S. Code for trademarks, copyright, and patents, and you see the corresponding title number here. So Title 15 for trademarks, Title 17 for copyright, and Title 35 for patents. Likewise, the regulatory framework, it will be contained in the Code of Federal Regulations, often abbreviated as CFR. In California, our state regulations are codified in a set called Barclays, and we're going to be going over this in the subsequent screencast for this week. Trade secrets are the one area of intellectual property that is historically governed under state law rather than federal law. Many states, including ours, have adopted the Uniform Trade Secrets Act, which in California is codified in Section 3426 of our Civil Code. Okay, some of the major secondary resources that you will encounter in this course will include treatises. Now I have a photo here of Constitutional Law by Chemerinsky as an example of a treatise. Of course, we're going to be using the IP treatises for this course. Treatises are single or multi-volume books that extensively cover a single legal area. Examples of treatises that are commonly used in intellectual property legal research will include Chisholm on Patents, which is available on Lexis, Nimmer on Copyright, and McCarthy on Trademarks. Actually, all three of these are available on Lexis. The corollary treatises available on Westlaw will include Moy Walker on Patents and Patry on Copyright. And again, we're going to go over this extensively in the next 8 weeks. Practice materials. Practice materials, as the name implies, are designed for working practitioners, not for law students, and they may include transactional forms, a newsletter service for current awareness, commentary, and analysis. For federal practice, we have really 4 major publishers of practice materials. There's Matthew Bender, which is owned by Lexis. Westlaw publishes their own series of federal practice materials. And then there are materials published by the Bureau of National Affairs, often abbreviated as BNA, which is now wholly owned by Bloomberg. And the Practicing Law Institute, which has content that is licensed to Bloomberg and also to Westlaw. We'll be using government resources extensively in this course, particularly when it comes to procedure and formalities for intellectual property. We will be looking at the USPTO website, the U.S. Copyright Office, which is actually under the Library of Congress, and administrative documents that are available via Hein, online, and other sources. And that concludes this week's screencast. If you have any questions about the course, feel free to email me or to message me in the course website. And I look forward to working with you this semester.